I would like to request Srimati Bidisha Banerjee ma'am to kindly take the dais. I would also request Mr. Bijay Murmuria to kindly take his stage on the dais. Welcome, ma'am. Srimati Bidisha Banerjee ma'am is a distinguished judicial member and the first woman head of department for the NCLT Calcutta bench. With a career spanning over 3 decades, she holds a distinction in being one of the youngest judicial members in the country at the age of 41. She has previously served as a judicial member of the Central Administrative Tribunal for 11 years, where she achieved the remarkable milestone of disposing over 17,000 cases across the Calcutta, Patna, and Ranchi benches. Before her elevation to the bench, she was a prominent advocate and served as the standing counsel for the Indian Railways from 2006 to 2010. Today, she is widely respected for her deep understanding of the corporate insolvency law and her nuanced handling of matters under the IBC. Her journey reflects not only professional excellence but also quiet resilience and dedication to justice, making her an inspiring presence on the bench and a significant contributor to India's evolving insolvency jurisprudence. We welcome you, ma'am. I would I would now request Mr. Nitin Daga and Mr. Binay Kumar Singhania to come up on stage to present the memento and Utriya to ma'am. Thank you. I would now like to introduce our moderator, Mr. Bijay Murmuria, sir. He is the Chairman, Finance Services and Subcommittee and a very senior member of CII. He is also the Director of Sumedha Financial Services Limited and the partner of Maheshwari and Associates. He comes with a solid financial background. As a practicing CA and IP, he ably guides all the issues pertaining to securities, shares, money markets, and insolvency cases. His unparalleled advice in the regulatory issue and domestic business environment are pivotal to success. Mr. Murmuria's intelligent foresight has influenced the company's business model remarkably over years. A key business enabler at Sumedha, he has made several presentations at various platforms of ICSI, ICAI, CII, ASOCHAM, and ANMI in India and abroad. Mr. Murmuria has also been actively associated with ANMI since the inception and was also All India President for the year 2008 and 9. We welcome you, sir. I would now request Mr. Vishnu Tulsiyan, sir, and Mr. Mahesh Gupta, sir, to kindly come up on stage and present the memento and Utriya to sir. Thank you. I would now hand over the proceedings to sir.
Good afternoon, everybody. First of all, thank you for the organizers to giving me this opportunity to moderate this session. More so, it is important that Madam Bidisha Banerjee is here, and everybody knows that she has been a great supporter of the insolvency process. And the day she has come, I think she has been very proactive and meeting all professionals also equally, giving time, and a lot of landmark judgments have also come through her. So while I will start this session, I will put one protocol that at the end we may have some questions. We'll put question answer, but let's not get into any specific case or question, be it generalized, so that and we should refrain from any personal photographs. So that be it, we start the process. So, as most of the delegates are aware, that Madam has been here for last more about 4 years, and being the judicial member and head of the department of NCLT Calcutta, Madam is best to say that looking back, how has been the landscape of corporate insolvency process evolved in Eastern India during her tenure, and what initial challenges did she face while Kolkata bench was getting evolved.
Thank you so much, sir. A very good afternoon to all the learned women and men present here. It's an honor to be here, to appear, to come before you and share my thoughts and views. Uh, in What I had expected is that we would be having an informal discussion in regard to the functioning of the NCLT and the challenges that you people face every day. Uh, so I'll just go through some question has been put for me to answer. I'll just try to give an answer to that. But I would also encourage you to come up with all your problems that you're facing in your day-to-day appearance before the NCLT or day-to-day proceedings that we take up every day. So I would be very happy to give my suggestions or to discuss with you how it can be resolved. So, coming to the question that has been put to me uh, regarding evolution of this IBC regime, I had put in around, it's not 4 years, it's more than 3.5 years. So, in this in this during this period, there has been, I've seen many amendments coming up towards improvement. Some impede our, speed. So it's a mixed sort of evolution, I would say. It's not very encouraging for the bench also. Uh, Rather, I would say that till 25, mid 25, I was functioning independently and there was a huge lot of disposal. Recently, many of you must have seen, even I have an other side. So it becomes very difficult to, speed up the entire process. So keeping our egos aside, if we, resolve to conclude a particular procedure, I mean, to give a closure to the process, it would be very helpful. And to that effect, I need full cooperation from all the professionals that appear before us or are involved in the matters that come up before us.
I think Madam has given a invite to people to ask questions rather than being a monologue. That's a great thing. But some of the question I'll put forth, then we'll, I think, open the question answer session. I think a lot of landmark judgments have come out of Calcutta, which has been pronounced in other courts as well, be it the third party security, which is now getting into the regulations also, preference shares rights, dissenting creditor allocations. So, as a NCLT judge, how do you approach balancing strict statutory interpretation with commercial equity?
Actually, sir, what we do is commercial equity is always will have a first place in whatever we do. But statutory provisions we cannot bypass that. We have to strictly adhere to what the statutory provisions are. What I find is IBC code is still in its nascent stage. There has been a whole lot of amendments, but still more and many more should come up, because the follow up of every procedure, it's not there encapsulated in the IBC provisions or its regulations. There has to be huge lot of amendments. Uh, in fact, what we were considering is suppose we get to sit together and find out what more provisions are to be introduced in the IBC, that would have been better. Whenever the need arises, IBC has been very active in introducing the regulations so that we do not find any difficulty in dealing with our everyday matters, but still more are required. Like you were talking about the security, third party security interest, there has been some landmark judgments coming up from Kolkata bench. I find it being applied everywhere in the country. It's a matter of pride for us. Like this preference share matter, it was my order, and the person who had helped me draft that is very much sitting here, Mr. Ronit Bose. So it was a wonderful matter where there was a EPC contractor who had some dues. The RP of the EPC had come up with an application asking for redemption of the preference shares. And we had said that once you enter into that arena where you uh, get the liability extinguished and get it converted into your capital, that particular nature and character changes. It becomes your share capital, not share capital, but preference share capital. But that debt gets extinguished. So you become an investor, not a debtor. So this has been upheld up to Supreme Court that preference share holders are not, creditors. They are investors in a company. So that was a landmark decision delivered by us. And thanks to Ronit for his extensive research. So, in the same way, there has been many judgments delivered by Kolkata bench, like this Gujarat NRE, Bharat NRE, the particular clause regarding going concern sale was introduced from this matter. Although it has been struck down now, there is no possibility. But had it been there, regarding some of the matters, we find that if had it been in place, there could have been better resolutions, better, giving closure to a particular process. Without this, a slump sale does not always help. This will fetch more return. This would have fetched more return or more money into the system. So at times, it could have been left to the wisdom of the adjudicating authority to apply it instead of taking it fully away, outside the IBC, domain. So this I have recently felt in one of the matters where this, going concern sale, if that was permitted to happen, state government would have come forward, taken, the burden of the farmers. It was in regard to a sugarcane industry. They would have taken the burden of the farmers. They could have paid off, and it could have proceeded towards a, fantastic closure. Instead of that, we are not able to find out how this can be managed at this juncture. Let us see whether it can be resolved.
The,
Over to you, sir.
the recent IBC amendments is largely aimed to strengthen the IBC ecosystem. One such introduction is the 14-day period for admission under Section 7 by the adjudicating authority, which would risk making the bench into a mechanical tool of the financial creditors and approval of documentary evidence filed therein. The power to adjudicate inherently should remain with the Honorable NCLT under the basic doctrine of Article 14 of the Constitution. Do you feel the middle path is the need of the hour?
This 14 days time period is too short. To be very frank, it's too short because even if you don't allow the corporate debtors to come up with a reply, they'll go and shout, cry horse that we have been not allowed. There has been a violation of natural justice. We have not been allowed to give a reply to the claim that has been put forth. And suppose we simply admit it, so it is likely to be challenged. And on that ground itself, it would be remanded back. So unless you give us time to go through the materials and to come up to a definite conclusion that there has been a debt and default, you cannot expect a proper order to be passed by NCLT or the adjudicating authority. So this window is too short according to me. there's also a way out that we have to be satisfied that there has been a debt and default, and unless we are satisfied, we won't admit a matter. So we keep on recording. I was saying on the previous occasion also, we keep on recording that this particular document is still required. We are not yet satisfied. So this is how we can, pull it to another 1 month at the most. But we cannot drag it beyond, possible limit.
So the
And
key thing is the satisfaction of the debt and the underlying documents, which the Honorable NCLT has to verify and confirm, and thereafter it can happen, rather than a very mechanical way one can proceed, which is in all fairness good for all the stakeholders and to avoid further litigation.
like this regulation 2B has been introduced, GSTR, this input tax credit, everything has to be looked into. You have to give us time to look into that. Who will do the exercise? It's very difficult. And why are you putting this in place? Because if you are asking us to go through it, you have to give us time to go through it. Or we have to ask experts to give your opinion on this, whether there is a debt and default, and then we'll admit. So in every matter, we appoint an IRP before admission, get an opinion, and then proceed in personal guarantor matters.
The next question, the Supreme Court has repeatedly upheld the supremacy or the primacy of the commercial wisdom of the Committee of Creditors. From the bench perspective, where does the threshold in between respecting the commercial wisdom and stepping into prevent arbitrary allocations or procedural unfairness lie?
Here we have, in regard to the commercial wisdom, nothing has to be said. The bank itself is present. They are the supreme. Their commercial wisdom is uh, beyond any adjudicatory process. We cannot step into that arena at all. So it's their call whether to how to evaluate. Suppose there are 3-4 plans, and how to evaluate and come to a conclusion to accept one. Even the Supreme Court says that even the Supreme Court does not have the right to, sit over the commercial wisdom of the COC members.
Now, a growing debate is on the operational creditor side, which is now getting more and more in focus. That there is some unfairness to the operational
Operational
creditor
creditors regarding allotment,
regarding allocation.
allocation of this thing.
So that is something which has been raised even at Supreme Court level, that something has to be done. Otherwise, we are putting those MSMEs largely into a insolvency
Further
regime.
insolvency.
So the spiral effect would have a damaging effect. So whether time has come to recognize those operational creditors in some methodology, and some balancing is the need of the hour.
Definitely, there is. Yeah, in fact, I remember in my first appearance before a conference of IBC regarding IBC, conclave or something, ICI maybe. Yes, I had said I was so surprised. What kind of this code is this? A operational creditor bichara comes up, files an application. At the end of the day, he gets zero, and he has spent so much on the litigation, so much on the lawyers. There is no payout to them, and nobody bothers to take care of the operational creditors. So if something comes up to take care of the operational creditors, obviously dissenting financial creditors and operational creditors both are supposed to get something out of the plan, minimum of the liquidation value, whatever, and ultimately they get nothing. In one of the matters, I remember we had sent the matter back. We found out that the operational creditors have been allocated nil. So their claim was around 5 crores. We sent it back to the COC for another round of consideration. What came back? SRA agreed only to pay 5 lakhs. Just imagine. And the person, had to be satisfied with it. So this I find, since I belong to a genre where, I dealt with constitutional matters, right of people based on equity and all, I find this to be very difficult to digest or stomach.
Ultimately, what happens, ma'am, is the SRA says to reduce this timelines, I will pay extra 2 crores and let the operational
Operation creditors be
creditor.
satisfied.
So at least resolution to hoga.
Resolution hoga. They are more into it. And the financial creditors are happy with what they are getting, the major chunk they are taking away.
I think we'll take few questions from the floor. So,
Ma'am,
Mike,
this modified version of 12A, modified version of 12A, has it not been suffocating because,
Absolutely.
yeah, that, because,
Absolutely. I agree.
yeah,
Fully agree. It could have been at the, at the initial stage, it could have been, there had to be a solution. Because I was going through a data published few days back. About 14 lakh crores have been uh, realized out of these withdrawals. So how can you
yes,
stop that?
exactly. And
At the initial
after
stage, if they
COC,
before admission, if they come, what is the difficulty? Even if after
yes.
admission, what is the difficulty? At least the matter gets resolved. Now you have to wait for the COC to be constituted.
So, ma'am, can you
Then
not use the Rule 11? I mean, who, as an adjudicating authority, does
show us the way.
anything?
Show us the way.
Rule 11.
Yes, show us the way. Ask someone to argue on that.
Yes,
That
ma'am.
this can be applied.
We have, but it doesn't find so much. I think because of the strictness of the law, that has been. But I think there should
There has
be.
been a recent decision
Yes, ma'am.
we had passed where this could have been at the even at the time of pronouncement this could have been the as I say I have an adversary so did not
Yes.
permit that to happen. Ultimately they that got resolved before the honorable NCLAT. It could have been even after admission they could have come up and you know got
So,
it
ma'am,
withdrawn.
then, sorry, for everybody's benefit, it is either, how do we come up? It can't be a revision application. So, it is a review, it can't be a review application
Cannot be
either.
a review
Exactly. So,
because you can seek a review only on limited grounds of
absolutely.
fraudulent
Yes, ma'am.
conduct
Yes,
of
ma'am.
the other side.
Right. So, that's
So,
what.
at the
and
moment, I think whatever is being done is done by Honorable NCLAT only.
Yes, so that's where
yes,
we are trying to
there is a
understand.
termination of CIURP.
That's what we are trying to
Although the
understand.
court doesn't provide termination, then they are allowing anything to happen even before constitution of COC because it's NCLAT.
At
So you give the
NCLAT,
same powers to us.
Yes,
at
yes.
NCLAT they
That's what.
say if all the parties are happy, why not?
Why not?
Ma'am, another thing, being the bar vice president, I'm just saying that, ma'am, nowadays litigation is becoming very expensive for us because whenever we are going, we can't go without a senior lawyer because we feel it's not only
No,
your
it's not
court,
that.
ma'am.
Not that. Not
It's
that.
not only your
It's
court,
a,
ma'am.
it's a very
It's becoming very expensive for the litigators. They are just not able to afford the litigation anymore in NCLT especially. This has become a very pertinent issue that we were discussing every time in our circles. Any litigation is not less than 50, 60 lakhs, which everybody and anybody can't
It's
afford.
not that.
I mean,
Why do you have to engage senior counsels? Tell me one thing. Why do you
thank you,
have to
ma'am.
engage? You are good enough. You are the knowledgeable people. You have every knowledge of every profession. So why do you have to engage another person to drag the matter beyond normal reasonable time? So you can very well place your matter. What you have to do is you have to place it in the form of a chart or in the form of something that we are able to understand. Maybe your technical member would have a better understanding and judicial member will take time to understand what the matter is. But at least at the end of the day, we are passing orders. And whatever orders you are getting from the high courts and supreme courts or in the previous regime that you used to get was from the judicial side. They were not experts, isn't it? So you have to come up with a precise and concise presentation of your problem. We can address on that. You need not engage senior counsels. I hope nobody is there.
In fact, on the contrary, in one of my cases at NCLAT, I saw that the other side has my counsel is a senior counsel of Supreme Court. So he's only attending virtually, and the moot idea is to take a hearing. That's all.
Absolutely, absolutely.
So I had to tell the client that you engage somebody who goes regularly to NCLAT. Otherwise, this will just go on for 6 months.
I've seen many of the known faces here, they appear on their own, they come up, argue their own matter. Mr. Tulsian is there, Ms. Binani is there, Mr. Singhania is there. You come up, in fact, in one of the Kufe matters, Mr. Rahul Parasram Puria, he was appearing. I don't know whether he is here today. He has not come. So he had presented the matter so well. It was on 43 and 43, 45 and probably 49. It was not on 66. If it is a 66, you have to see the underlying intention. You have to, we have to come to a finding that there is element of fraud or ill intention on the part of the this suspended board or directors who were there. So if it is not that, at least for this part, the RPs can come up very well. They can, give a
I,
chart that this has been the transaction. This was the value. This has been the transaction, and it has been sold at this.
I would say the
In
RP
fact,
is in a better position.
Ms. Nimisha Agarwal did wonderful in one of the matters. She had engaged our senior counsel, isn't it? She had wonderfully presented by way of a chart. We were getting, in fact, I was getting confused. What is this going on?
Madam, in fact, RP is in a better position because
To
with,
explain, yes.
with the accounting background,
Absolutely.
he has much more control on the audit trail and how and what happened.
Yes, yes. Only that there has to be a formation of opinion, which I always say that before coming up, there has to be a formation of opinion. That is not required if the suo motu, we direct that same to be taken up for consideration. Their formation of opinion is not required in case of the RPs. But at least you can very well place your matters. There is no difficulty at all.
Presenting three type of cases. Mainly, one is 19.2, one is PUFA application, and another is resolution plan. These are the most three important applications which a resolution professional file before the adjudicating authority for the matters which they are more concerned with. So, what the bench expects from these professionals while framing these applications, because the facts are best known to the RPs only.
Absolutely.
So, how the bench expect that?
I
what
would
should
always encourage the RPs to come up and say what problems you are facing in regard to 19.2. What is the problem you are facing? What they are, preventing, leakage to you. I mean, giving the opinion, giving the information or documents, whatever is required to be given to the RP for conduct of its
practically
duty.
practically what happens in most of the cases which are coming into IBCs now, the operations are being closed, there are no employees. Now the director says simply that some accountant was looking after all the matters, I don't have any access to the data, accordingly I cannot give you anything. That is the most pertinent answers from maximum of the promoters
So in
and
that
directors.
case, you have to come up and say how you can retrieve the data, from whom you can retrieve the data. In that case, you can implead those persons so that we can call them up, ask them to give the data. If they don't, we can issue arrest warrant. Not only against the directors, but also against the
So
persons who
even
are
the ex-employees.
preventing that information to come to you.
Okay.
I have been telling it again and again. Why don't you come up when 19.2 application is being filed or moved? Because your council won't be able to give that picture to us.
Definitely.
What is the difficulty? If you are not being getting access to a particular place, what is the difficulty? Identification of a particular.
The main problem is access to data. If we
access
get
to
the,
data.
if we get data, there is no problem. But most of the time, as I have said, that the
You
promoters
tell
or
us
the
who has
directors.
the data with him.
That also they don't say now. The problem is that they don't say that some employee might have who have left,
So
they might have.
then just tell us how do we find who has the data? Only then.
It's
Suppose
a
you
practical
impede
problem.
that particular person or tell us that this person would be having the data, we can ask them to. Even we have issued arrest warrant, the directors have come up disclosing who is the core person.
So we have to
who has-
personalize and earmark that, okay, this person
One
is
threat of
responsible.
arrest warrant, they come up and.
I would like to pitch in, lot many times the 19.2 application is vague. We have
Yes,
to be very, very
No,
pointed.
no, specific.
We have to be very pointed that these are the missing data. बैलेंस शीट अगर नहीं है तो किस साल का नहीं है, क्या हमको एग्जैक्ट चाहिए, फिक्स्ड एसेट रजिस्टर चाहिए, ये चाहिए. And
वो तो है.
in case we have to name and let the directors appear before the court.
सर हम लोग तो आजकल क्या करते
threat
हैं,
itself,
बिफोर फाइलिंग एन एप्लीकेशन देयर आर एटलीस्ट 4 or 5 मेल स्पेसिफिकली आस्किंग फॉर पर्टिकुलर डॉक्यूमेंट्स दैट दीज आर द थिंग्स व्हिच वी रिक्वायर फॉर प्रिपरेशन ऑफ इंफॉर्मेशन मेमोरेंडम और knowing of the
we should
CD.
press before madam that these are the specific points which we require, and let there be a physical presence of the director on the next hearing.
Okay. Thank you.
You implead everybody when you are filing an application. And leave it to us. We'll call everybody, and if they don't share the data, we'll issue arrest warrant. And that is helping in one or two matters we have seen. They are coming up and giving.
And practically what happens,
disclosing
because of
everything.
absence of data, we are unable to determine or make an opinion on PUFE transactions as well. So practically what happens? So
In one of the matters we had seen suspended board not giving tally data.
Huh.
The tally person was called. He was giving data in regard to some other years of previous years. Then we said, what rubbish? You come up with the proper data. He said, no, someone else has it. So we issued arrest warrant. What to do? Then let us find out whether this is shared or not. By the time the plan has come. And regarding some other question you had 19, other than 19.2, there was
Resolution plan.
resolution plan, of course. Yes, at the time of moving a plan approval application, some informations are there which your council won't be able to place before us. Suppose a particular question is being asked in regard to how did the COC ascertain the feasibility, viability of the plan. There were 2-3 plans. There is an objection to a plan by an unsuccessful PRA. So how was this? Although it's not material because their commercial wisdom is the supreme. But still, in order to prepare an order, we have to find out, we have to justify. Regarding this last order, the judgment which had come, Torrent probably, the judgment of Torrent. Although Supreme Court says that we cannot enter into this arena of commercial wisdom of the banks, but it discussed everything in details. It had to, because it had to pass an order that we were not supposed to enter into that arena. If they have taken a decision, it is rightfully taken. Only to substantiate that part that the decision taken by banks or the COC members was correct, it had to go through the entire hog of materials and come to a finding. So this assistance won't come from the lawyers. It has to be from the professionals, the CAs and the CS. And let me share one thing, one very interesting thing to you. Recently, I was attending a conference of the banks. I had met a person who was, said that the CAs and CS of Kolkata, they have the most fertile brain. Entire country watches them how they bypass provisions to get something.
Jugaad technology.
Yeah, may I?
Yeah.
Yeah.
So you should take that as a compliment.
I am Ravindra Belayur
He
from.
said, the person said that they are most intelligent people throughout India.
Yeah, Ravindra sir.
Yeah, I am Ravindra Belayur from Bangalore. I am not privileged to be before the honorable bench anytime in Calcutta because I am based at Bangalore. But thank you. But I do have read many of the orders of this honorable bench, and they are very useful to this IBC ecosystem. Thank you, madam.
Thank you so much.
Yeah. My question.
Do get a chance to prepare, appear before us.
Let us see. Madam, my question is, we are already about 10 years of IBC 2016. It is understandable that when the law was made, there was a provision that RP to be replaced without giving any reason. The thinking was that it will lead to a lot of litigation for change. I am asking a question in the context of having been replaced at least 5 times as an IRP for doing good work in the sense, in all these 5 cases, we have filed avoidance transaction anywhere between 3 to 6 applications before handing over the charge to the RP.
And in one of the matter, based on the representation, serious fraud investigation also happened. So, so as it happened and is going on. So in the context I'm asking is it just because there is an NCLAT order that the adjudicating authority has to necessarily replace just because there is no reason to be given by the COC? Is it, and since 10 years have happened and we are much matured system, is this the time for change in line with the laws in other countries including UK, where a RP administrator RP has to be changed? She or he is an officer of a court. It can't be changed without giving reasons. This is my question based on my experience. Thank you.
No, of course, when applications come up before us seeking change of the IRP, I mean, its confirmation of IRP can always be, there can be a different person confirmed as RP. But when RP itself is getting changed, we always ask for the reason why, what is the reason? Although we cannot do much, but in matters we have found that suppose the RP is taking steps which is going against the members in the COC, there is a likelihood that the RP gets changed. So you have to be very, do a balancing act. You have to try to keep everyone happy. That's the way out. It seems.
But anyway, just to tell you, unfortunate part is these are the cases where these COC members have already taken away the assets of the corporate debtor with the collusion of this one. But an independent person cannot do the balancing act. He has to be very.
So if he has taken it out, obviously he would come with avoidance transaction applications.
I mean,
Sir,
the
You have
RPS
to
are
claw it
changed.
back and bring it to
I
the,
think in most of the cases, what you are suggesting, the prevalence of financial creditors may not be there in the COC. It is maybe that the operational creditor or some unsecured financial creditors are holding the COC voting power. Because generally, when the financial creditors are there, they are much more pragmatic in choosing the right candidate, and if somebody is doing the right work, normally they don't change.
No, I agree with you. These are all the cases. I mean, in
like there are fortunate persons who have never been changed.
no, no. These are the cases as you Murmurji shared. At least 4 cases are where it is not the financial institutes like banks who are the what you call COC members. It is the
So I think
Private parties, okay.
that problem would remain in the system. Thank you. So we are coming towards the end. I think the closing fireside question, looking ahead at the decade of IBC evolution, what is the single most critical practice shift you would advise IPs and legal counsel to adopt when appearing before NCLT Kolkata?
If you appear, yourself, try not to engage a lawyer. It's not even required. In case you feel that there are things which can be better placed by a lawyer, Ronit should not divulge it. I hope he won't. So, in that case, you can definitely engage a lawyer. But when you are coming up to do a matter yourself, prepare a chart. You should be posted with the facts properly. You number that this I have to deal with all these things. So 1, 2, 3, 4. In that way, you have to prepare your statements. Prepare a chart. If you want to give the judgments, supporting judgments, please do it. Give written notes of arguments. Keep it handy at the time of hearing. Give it to us. Then place your matter. I don't think there would be much difficulty on the part of the RPs to come up and place their things. There are petty matters which you can every day deal with it. I don't know what keeps you engaging the stalwarts in the legal field. It doesn't help. It doesn't help. In fact, it drags the matter beyond reasonableness.
That also helps.
No, that doesn't help us. Because at the end of the day, what happens is every month I have to give a report.
No, not to you, to somebody.
Yes, no, absolutely, absolutely. But don't help them. So at the end of the day, when we prepare a report, why is this pending for so many years? We have to give this thing. We have to give our reasons. So that is not good for us to every time be bogged down with all these formalities. So better you get it done at the earliest. That is the only way it can be resolved. And we have to, even as an adjudicating authority, we have to seek your help for a proper closure within time. In fact, I have found in some of the matters we have engaged, we have changed the RP. It has helped. Suppose, like in Humbaya matters, we have changed the authorized representative. It has helped. It has come to an end. So we also, with my experience of more than 3.5 years, I also can make out who will be the effective person to be engaged. So accordingly, we plan our move.
I think ma'am has shared a lot of mantras today for adoption. So it has been a really great session. Any final question, or we can come to the end of this session?
Yeah. As per CIRP, the time
This
period
is the
given
last question.
Time period given is 180 days, and it can be extended to 270 days or 330 days. But it is going beyond the longer period, and all RP has several means there are several IAs, litigations are there, 19 to there. We have all so many replies to that one. As a judiciary, as per judiciary, how you can see what are the main reasons for going beyond that 330 days or 270 days?
Going beyond I was going through a data which says that even admissions are taking more than 700 days.
Yeah.
Many of the admissions have taken. So you're talking about the
CI.
post-admission, where people keep on coming up with frivolous applications at every stage. You people, RPs, come up only when they are unable to handle a particular situation. They come up with an IA and ask for some help from the adjudicating authority so that the procedure gets finalized at the earliest. Other than filing progress reports, these are the applications. But so many, SBOD comes up with so many applications. Then there are at the plan stage or implementation stage, so much problems are there. Liquidation stage, RP has to run around the country if the assets are situated here and there, get that resolved.
So can
So
we
this,
do?
you cannot give a particular time period to every process. Some can be, of course, disposed of within 330 days. We have seen many of the RPs are proactive and getting it done within a period of 300 to 400 days. But there are matters which takes time because of the complexity of the nature of the matter.
So can we take a suggestion to the IBPI or other people, like a frivolous IAs are there?
What
Then-
will you do?
Yeah,
What suggestion will you give to IBVI?
yeah.
We can impose cost, we can impose fine. Of course, we can.
But yeah.
Yes,
of course. All those amendments are there, but how to make it sure that these are the frivolous ones? That's the thing.
Yes, even that needs a hearing. That needs a hearing. So that will consume time.
Yeah, that will consume time.
The hearing cannot be one-sided. You have to hear out both the sides.
I think there I have heard ma'am saying, "Kitna application daloge?" In open court, she has said.
Because we see one matter having 3 to 4 causes, and there are a number of IAs, developer application, contempt applications together in only one application.
Then there are also difficulties which I have seen. Members, if they are in perfect sync, if there are ego problems between members, it takes time.
So with that note, we come to an end of a very, very enriching session. Thank you, madam, for all your mantras. I think everybody of us has got enriched by it. Thank you.
Thank you so much. Wish you all the best.
I would request Mrs. Mamta Binani ma'am to kindly give the vote of thanks.
A very difficult and a daunting task given to me, but I'll try to do justice by just saying maybe one short story, very, very short, that there was an engineer, and there was a doctor. So engineer ma'am asked the doctor, मैं भी ऑपरेशन करता हूँ, आप भी ऑपरेशन करते हैं, ऐसा क्यों है कि you get so much of money and I get peanuts? So here is, you can tie your seat belts if you want. The answer is very zealous. So the doctor said, मैं चलते हुए हार्ट रहते हुए दिल के साथ ऑपरेशन करता हूँ. विच मीन्स जीता जागता आदमी जिसका हार्ट चल रहा है, सारे ऑर्गन्स चल रहे हैं, उस पर मैं ऑपरेशन करता हूँ. और इंजीनियर साहब, आप गाड़ी बंद करके ऑपरेशन करते हैं. Insolvency law is all about insolvency professionals working against the tide and trying to bring resolution. Equally important is, if not more, is the adjudicating authority who, with all the tides coming from all the sides, एक तो आता है ज्वार भाटा सामने से आ रहा है, एक ज्वार भाटा चारों तरफ से आ रहा है adjudicating authority के पास, and in spite of that, ma'am, we are so grateful that you are with us in Kolkata. We are privy to what you operate, how you operate, and the kind of opportunities that you have given to all of us, and the confidence that we gain after we appear before you. We learn so much. And if the best thing that we have all learned from you, I think we all will resonate, is having patience and calm and poise. Is it not? Thank you so much for all of it, ma'am. Very grateful. Thank you to Mulboria Sahab also for giving his valuable time.